Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, attorney Sivonnia DeBarros uses the contract that turned Dwyane Wade into an underwear model to teach us about name, image, and likeness. So, let's tear it down. Welcome back to the Contract Teardown Show from Law Insider. I'm Mike Whalen. I'm here today with my friend Sivonnia DeBarros. Sivonnia, how are you today?
I am doing so well, Michael. Thank you for having me.
I'm glad to have you here. We're going to do something that's a bit timely because, as all of the viewers and listeners know, we're in the middle of the NBA Finals right now, and the Miami Heat are in it, and there's just incredible stuff. Okay, half of you probably don't know this, but we are going to talk about Miami Heat royalty today being the Dwyane Wade, however you spell it. It is the man. And we're talking about contracts with athletes. Let me share with the folks at home the contract here. This is a collaboration and endorsement agreement as between Naked Brands and Wade Enterprises of Dwyane Wade. Sivonnia, tell me about this document. What is it? When are we going to run into this kind of document?
Oh my gosh. Okay, so this document is an endorsement contract. So when we hear about athletes having appearances or engaging in some form of brand collaboration or brand deals with companies, these types of contracts will typically come up. So now we're seeing student athletes who are able to get these types of endorsements and sponsorships. And so this is, when I saw this contract, I was like, oh, this will be a perfect example for today, because athletes have been making these types of deals for a long time, but now we have a new demographic who's able to move into this space. So I think it's going to be amazing.
Yeah, it does make it interesting because the principles are similar, but the power structure is very different, and how they're, Dwyane Wade is retired and not playing. And so how does that affect, these college athletes who are in the early days of playing and trying to capture some value, versus the risk of injury or whatever. So it's an interesting context. You are working on these kinds of issues all the time, Sivonnia. I've heard many conversations with you on podcasts and including your own. Tell us about you. What's your background with these kind of agreements and what you're doing for student athletes?
Oh my gosh, my background is the protector of athletes. Okay, let me just stop for a second. That's my brand, of course. So I absolutely love and adore the protection aspect that I carry for athletes. And now I have the ability to do that in the collegiate space for student athletes. So right now I have been, for the last several years, really on a mission to capture their attention and educate them around these issues, because I don't think many of them think of name, image, and likeness, the infamous NIL, as intellectual property rights. And so when we tear down this contract, we're going to see how those come into play. But my background is as an attorney. That is my bread and butter, and my levels of protection have pivoted over the years. And it's also pivoted in a way that has helped me to be in spaces and be around individuals and clients where I've been able to, handle multi-million dollar deals. And sometimes that looks like me going to trial for them. So, it's important when we're talking about contracts, sponsorship contracts, or endorsement contracts, or whatever the contract would be, that the athlete understand how it is going to operate for the long term, and how they're going to be able to enforce their rights and protect their brand for the long term outside of just that contract. So that's a little bit about me.
Got it. Well, let's dig into this document. The story that I read, you never know if this is just marketing speak or if this is true, but that Dwyane Wade's wife bought him a pair of underwear. He put it on. He said, "This is amazing. Go find that brand. Let's figure out how to communicate." So this is the story of how Dwyane Wade became an underwear model. So Naked Brands is a company that creates innerwear, they refer to it as, and Dwyane Wade, obviously the basketball player formerly of the Miami Heat, and a very weird term with the Cleveland Cavaliers that I think most of us would rather forget. So he reaches out to them. He says, "I'd like to collaborate with you." This is the resulting agreement. Let's go into it. First of all, talking on a bit about the background, is this a pretty typical agreement? What usually happens with these kinds of relationships, particularly with student athletes? Who's reaching out to who? I wonder about the general power dynamic in agreements like this typically.
Both, really. Both. So here's the thing. So now that we're seeing some of the more popular athletes rise to the top, bigger brands are typically reaching out to them, right? However, it does not mean that student athletes who are not getting that type of publicity can't reach out to those brands themselves. So there are a few athletes, I had a few of them on one of my events last year, who have NIL deals. They are not the most popular athletes out here that's, blazing media all over the place, but they do have deals. Now, in terms of the power dynamics, it depends. If you're a student athlete who have major star power, you might have more of a power dynamic. However, the company who has years and sometimes more than 20, 40 years of experience in being in business and creating these deals, they have more of that business savvy, and that creates a power in and of itself. So if you don't have people on your team to help you, even if you have star power as a student athlete, you could find yourself in a situation where you're going to be begging or crying around your brand, your intellectual property, because you possibly could have put yourself in a position to have sold it off without even thinking. So it's a little tug of war, little balance, but it kind of just depends on, your particular position when you come to the table.
All right, so on this one, Dwyane Wade is creating his own unique line with Naked Brands, which is an interesting dynamic. But it means that they need to use his image. So I'm going to jump down to Section 3, use of Wade image. There's an exclusivity point in here. Naked shall have an exclusive right and license in the territory to use athlete's name, nickname, initials, autograph, image, likeness, photographs, biographical details, facsimile, signature, voice, etc., etc., etc. I'm seeing the word exclusive, right, and license. I'm seeing the word territory. To your point, that sounds like a lot of intellectual property terminology. What do you think of the language in this exclusivity section?
So one reason why I wanted to talk about this exclusivity piece is because when we hear of exclusivity and as well as perpetuity, most people see them kind of going hand in hand because those are like the I got you terms, all right? So here's one thing about this exclusivity for Dwyane Wade. It makes sense for the company to say, hey, we're going to have to utilize your intellectual property rights, your name, your image, your likeness of whatever products you might currently have for purposes of being able to fulfill this contract. But if they are wanting to utilize his brand's exclusive period, even if he wants to do business with someone else, that could pose a problem. So there's somewhat of a contradiction for me in the contract. When we look at the first statement of exclusivity, okay, yeah, you're going to give us an exclusive license technically to utilize this information or to utilize your intellectual property in the territory that we base in this contract. Okay, that makes sense for the particular term that you have. However, now if you're saying we're going to have exclusive rights, period, and you can't go and advertise or do business with any other company that's selling or manufacturing products that are similar to ours, will that pose a problem? So it makes sense from a business perspective because I wouldn't want to have competitors, out there in the exact same industry producing the exact same clothing. But what does that do for Dwyane Wade, or what would that do for another athlete who's similar to him who might want to do a deal with joggers, or jeans? Would that be a contradiction to the contract? Would that be a breach to the contract? And so we want to think about exclusivity when we're coming to the table and thinking about the timeline of exclusivity as well.
Yeah, there's a point later where it specifically excludes another brand that D-Wade is working with, and we'll get to that. But to your point, let me read the language in the exclusivity section specifically, which is 4. Wade agrees that during the term of this agreement, he will not represent or perform as a representative, spokesperson, or provide Wade services for, etc., for advertising, endorsement, promotion, or sale of innerwear in the territory, so they get specific. Wade will not engage in any business or other transaction or have any financial or personal interest with any entity whose primary business or core business is selling innerwear during the term. There's a lot of caveats in there, right? Like, and to your point, I think there's this question of how narrow does the language have to get to say, I'm not competing with you? Is it you can't do a deal with another motor vehicle company, or can we separate out cars
Correct.
and scooters, or big
Correct.
cars and small cars? So talk to me about the language. It's very specific. Do you like that? Do you think that's useful for a student athlete looking at documents like this?
The language was a little bit concerning for me. And to your point, it excludes. So later in the contract, it does exclude one particular business collaboration or deal that Dwyane Wade has. And I'm assuming he had this deal when he came to the table for Naked, right? So the same thing could be in existence for a student athlete. But if it's going to exclude other brands after the official or date of signing now this endorsement contract, that could be a problem, because it could cut off any and all other opportunities that could come to that athlete's plate. For instance, even Dwyane Wade in this contract, what other brands that will not pose a threat or an issue, right, to this collaboration contract with Naked? Would it make sense? To your point, like if I wanted to do a deal with a car dealership, is that really going to be a breach? Is that going to pull dollars away from Naked? Not necessarily, right? Two completely different industries. So I think being technical in the language is a good thing, but if we're limiting it, we have to be very careful about how we limit the language, because it can be so limited in a way that it could box that athlete in. And if you do something, we're lawyers, so we know how to play with the language, right? We go to court and be like, oh, well, the parties did not agree to X, Y, and Z. They agreed that there would be no outside engagements other than the previous collaboration that was previously brought to the table, before entering to this agreement. So we have to be very, very careful and make sure that it's not going to foreclose other opportunities that could be out there that does not pose a threat to the contract.
Right. It uses the language specifically of primary or core business. Well,
yes.
Can he do a deal with Old Navy now? I mean, Old Navy has underwear in their store. They have shirts, undershirts in their store. Can he now, what does core or primary mean? It's an interesting question. Something specific that I don't know if this is true in other sports, but one of the most fascinating thing is the number of NBA players who have their own logo. I just find it fascinating that they all get drafted and they're like, what I need is a logo that looks like, Donovan Mitchell has his spider and it looks like a spider. I found out the other day that Jamal Murray has a logo, for Pete's sake, of the Denver Nuggets, and this is, he's big probably in Denver, but he's not Dwyane Wade, but he's got a logo. I feel like the only person who doesn't have a logo. Anyway, this document does specifically mention logos created for Dwyane Wade, either with this line or elsewhere. When you're thinking about this as intellectual property, there are images and symbols and brand tools being created both for this deal and for the other deals that Dwyane Wade is doing. What do you think about, kind of crossing those things? Presumably it adds value to Naked to have a Dwyane Wade logo on there in addition to Dwyane Wade's face. But now what rights has he given up? What do you think about the use of his logos in this scenario?
Yeah, so in the prior language, it does say, okay, you're going to give us an exclusive license. So for newer attorneys who might be listening to this, or athletes, license is basically you're granting a right to that person to utilize something that you own. So yeah, they already have a license for the logo that he might bring to the table that he already, owns or whatever. But the biggest issue I have, they recognize that he owns anything that he creates, but going into a collaboration, now if you are collaboratively creating something, you don't own that exclusively. You don't own whatever creations you've made exclusively, whatever names that you've created for your collaboration exclusively. And I'm also concerned around whether, if they're helping him to improve on a logo or any kind of trademarks that he brought to the table, will he have technically transferred some form of right to Naked in that intellectual property? So it reminds me of Kawhi Leonard with the claw logo. When he went with Nike, he wanted to leave, and Nike was like, no, bro, that's our stuff. That's our intellectual property. You cannot take that. And he admitted that Nike substantially improved the logo. So now we're looking at a situation of, even if I brought intellectual property to the table, will I own it when I leave this relationship? So we have to be very clear and careful about how we construct the language around the intellectual property that we own when we go into those contractual dealings. As an attorney, I would have tried to be a little bit more specific, around not only does Dwyane Wade own the logos that he creates, but any improvements or what have you would also be owned by Dwyane Wade. And another thing that is concerning here too is when the collaboration ends, what happens to all that intellectual property that's been generated over the last 4 years of this contract term? Is there a buyout, period for this? Now, I do like how they calculate, royalties, and we'll get to that inside of the contract. But if there's an issue or a question to who owns the intellectual property that was created during this collaboration or by nature of improvements of the intellectual property, how can Dwyane Wade keep the rights to that?
There is, as an aside, a sentence that I find fascinating that we're jumping down to, because I can't tell who wrote it, right? Like, who does this benefit? And it says that the parties recognize that the athlete is the essence of the contract, which is a fascinating phrase. That it's his accomplishments and recognition as an outstanding basketball player, individual and fashion icon, as well as his character, fame, likeness, image, and reputation, that they're the essence of the agreement. Wade warrants that he's not a party to any agreement that would limit his ability to be in this. And then it specifically carves out this other agreement for shoes and athletic apparel, which is different, apparently, than being an underwear model for naked. But it's just an interesting, maybe this is getting sort of big picture a bit early, but the athlete being the essence of the contract, I can't tell, is that the brand wrote that and said, hey man, we own all the stuff that has to do with you. We get to capitalize on everything that has to do with you. Or is that the athlete saying, look, I'm the show. Okay, so you guys can't do anything. This is not just about products on a shelf. It's person. It is like my personhood. You can't go do things with me as a person that makes it so my person reputation, there's no way to compensate for that in the way that there might be if Coca-Cola, enters a deal with AMC or something. There's no way to compensate for hurt to character. What are your thoughts on the way this is phrased, that the athlete is the essence of the contract? Who's this protecting? What do you think about the language?
It is very confusing. And I thought it was interesting when I saw it, because typically when we see essence anywhere in the contract, we talk about executing it in a time of essence. Time is of the essence, technically. But when I read it, it was, like I said, very confusing, because you cannot distinctively say, okay, is the company naked putting this in here from a damage value, right? Sometimes companies will say, well, hey, you understand that trying to computate actual damages would be very difficult. So in the event we end up in an issue, the athlete is the essence of this contract. So how are we going to value, any damages that could result from the athlete not performing? But then I can also see the athlete saying, well, for me to protect my position in this contract, you need me. So you know that you can't do anything else without me. So it really, it's hard to explain it, but even that piece needs to be a little, more clear. Definitely need more clarification, because it's so ambiguous. I don't know why the athlete would be of the essence to the contract. Yes, they have fame, they have celebrity, but so are many other athletes out there who have fame and have celebrity. What else does the athlete bring to the table that is a value add to Naked outside of him being a celebrity professional athlete, right?
Yeah. It's so interesting, especially in the NIL, in the college athlete context, because the whole point in that fight was these athletes saying to the colleges, you don't own me, right? And now we see the transfer portal and the ability for athletes to move colleges and how easy that's become, because that whole fight was about saying, you don't own me, right? Like, I may go to this school, I may play for this team, but I'm the show, I'm the thing. Switching and doing that for corporate brands. We could talk about that at the end here, but that doesn't seem much better. So again, was this D Wade saying I'm
Right.
trying to protect myself, or was this the brand? It's an interesting question. Well, let's get to the last bit of language, and then we'll ask some of those big picture questions. Under 8, it talks about royalties, collaboration. There's a lot here. And I want to dig into the specifics as much as you want in terms of how the royalties are calculated. There is a blank space there for minimum royalties, which we've talked about in contracts before, which is interesting. I think it was a Cardi B contract that we did that had that, which is an interesting question. But in general, there's a relationship and how we're monetizing that relationship in this scenario, including comments about board membership.
Yes.
Talk to me about this section about value transfer. I mean, we're using the term royalties, but we're really talking about value transfer in general. Who's doing what? What do you think about this section?
Yeah, so this was quite interesting too, because as you know, there are a lot of athletes who are re-educating themselves now on being paid through equity, trying to create something that is long-term and sustainable. However, if you're, going into a deal with a younger business, you might not be able to really make any equity. So I thought it was interesting here. You have a very popular professional athlete who could be paid millions just to go into an endorsement contract, right? Or some kind of collaborative deal, but opts for, a royalty schedule on any of the sales for the collaboration, but also the equity piece of the company. Now, when we're talking about equity, typically we're talking about someone becoming a stakeholder in that company, someone receiving stocks, or if it's an LLC, the membership interest of that company. So seeing that makeup wasn't surprising to me. The only thing that was a little, in terms of the payout, the only thing that was surprising for sure was, I'm like, okay, Dwyane Wade isn't going to take a little seed money on the top. Where's the actual monetary compensation on the top? And then, okay, royalties, after whatever period over however much time. But another thing that was confusing or concerning that I saw was at the end, and they have the sell period, almost like a winding down period of when Naked will continue to sell whatever products that they've created throughout that time that could go past the last day of that contract period. What happens if the product is great? Are they going to stop completely selling the product? What if people continuously purchase the product after the sale period? How long is that sale period, right? Because if something is great inside of that contract, how could Dwyane Wade create a compensation model that is favorable to him? It reminds me of Michael Jordan, right? He's like making bank forever off of the Jordan tennis shoe. So the same thing is in my mind around this language for the royalties and the equity. And then I was confused about, okay, why would we have a fully diluted stock? And so for those who listening, diluted stock is basically your stock has been converted. But they also have said, okay, well, you also recognize that we're going to put you on the board, going to have a seat at the table, basically, and you're going to give us permission to share that with people. Okay, well, what are going to be these responsibilities on the board? And if you are a younger student athlete or someone who's advising a student athlete about maybe taking equity and being on the board, we have to think long term too about that. Is this a company that is that you really are in alignment with? What kind of decisions would you have to make as a board member? When you are an officer of a company, right? What type of legal responsibilities will be at your feet? That's a lot. That is a lot to juggle. So if this company goes down, you might also have a bad look as well as that board member / officer. But it also depends on how they've written his equity in, or what type of position he would have as an equity member, which I would assume would be in a separate stock agreement.
And you see in this something that is unique to Dwyane Wade as a person that makes it hard to tell, again, who wrote this. Is it that they wanted an accomplished business person with connections like Dwyane Wade, or was Dwyane Wade saying, I'm not going to be associated with a brand that I don't have some control over the outcome? And that brings us to the student athletes, right? That was the original context that you brought you and me together with this question of these student athletes now being in a position to make these deals. Obviously, hard to find those deals in publicly available documents because they're relatively small deals where this kind of deal is much easier to find. It's much more likely to be filed. So for that student athlete, they're not an accomplished business person, right? They're probably 18. They're not retired. They don't have Dwyane Wade doesn't have the risk of injury that these younger people do that could completely undermine careers. So they better get some money from video games now. There's some context changes, right? As soon as you jump from somebody like Dwyane Wade to a student athlete. So just for a minute, give us that big picture sense. What can a student athlete learn from this kind of context? How do they adapt what we've talked about the power relationship between a retired Hall of Famer versus their circumstance? What carries and what doesn't?
That is such a great question. I think I think the biggest thing that a student athlete can learn, and let me just clarify this too. Are you saying from the contract period or from this payout section?
From the contract period, yeah. The thing about the contract in general and the negotiating power, we've identified a few points here where it's not clear who's the boss, right? Like
it is not
normally the brand is the big business and they're making the deal with this little guy, but that's not. I don't know who Naked Brands is, and I assume that's true for most people. So sort of a weird power dynamic, but with student athletes, it might be different.
Yeah, and you know what? Before I answer that question, let me just bring this out to you because, and this is going to fold into my advice to answer your question, but there is a section here in the contract where when we're talking about the collaboration, and Wade is basically their creative director. He can approve images, but over and over they talk about, okay, well, you cannot unreasonably withhold approval. There is no description in terms of what unreasonable means. So for student athletes, if there is something I think here's the biggest thing: alignment. Authenticity. Know who you are before you go to the table. Because if you are put in a position with a brand and you know that something is clearly in disalignment, out of alignment with you, with who you are, with the brand that you're creating, with where you say you want to be 10 years, 20, 30 years from now, but you might be deemed to unreasonably withhold certain approvals or not be a team player as they may describe you, would you effectively have become, a breacher? Would you have breached or the agreement that you've set out to carve, with these individuals? So it's so important. Number one, think about who you are, where you want to be in your life. What is the end game? I think too often we think more short-sighted around, okay, well, I want to make this money now, right? I want to get this check now, but we don't think about how it could backfire on us. We need to think holistically around name, image, and likeness. I love how this contract broke out every single piece of what could be a name, image, and likeness, nicknames, what people might know you by, if there's a tagline that you've created, if you do have a logo, if you have an image on something that you've created yourself, so you really want to think hard about how have I described and illustrated my own personal brand, and being clear about how you're going to protect it inside of that contract. Okay, so we talked today about a lot of language that I could assume was drafted by very well paid attorneys, right? And there are still questions that both myself and you have from this contract. So it also means that you have to have competent counsel with you and supporting you. You have to have people around you who are going to help you to talk out this language, like help you to really ask some of the tougher questions of, what's going to happen if I want to do X, Y, and Z? What's going to happen if I want to create another brand deal with somebody else? Is this going to be a violation of this contract? But also bringing it to the table for those executives, those decision makers who are interested in you. Because I'm telling you, the best thing that you could do at the start of any relationship is to have those hard conversations that you're too scared to have initially, because it will remove a lot of the angst. And in most situations, you can rid yourself of those issues that could become very legal snowballs. I've seen them. I'm a trial lawyer, so I deal with them all the time. But I think if I'm going to boil this down for student athletes, it really just comes back to knowing who you are and what you want, and making sure that these brands, I don't care how much money they have, I don't care how many multi-billion or trillion-dollar, statues that they are, you have to come to the table knowing about who you are and what you want so you can properly protect it in the meantime.
Well, I think for the attorney, you have to recognize in terms of the business model, the way these players are creating value and the way they're capturing value are not the same. They're independent, right? And you have to protect both of them. I'm reminded of a Best Buy, right? Like Best Buy created value as a showroom, and it used to be that they captured that value by selling CDs to people, but then Amazon showed up and now they sell space as a showroom. So the way they capture the value is different from the way that they create it. And as a lawyer, you have to understand that business model, that these student athletes, these athletes are creating their value on the floor, and then they're capturing it in these other ways. And you have to protect both of them. So it's
such a very small window too. Yeah. So this contract with Dwyane Wade talks about 4 years. Well, most student athletes are in college for 4 years. You're playing for 4 years, right? So think about your window of capturing that attention. Do you want to be locked into something for 4 years that does not allow you to maximize and fully leverage your intellectual property rights, your name, image, and likeness over that time? So it's so important to think about that. If any company wants to exclusively work with you, okay, you know what? Flip it on its head, right? Instead of you saying, I'm going to give you exclusive rights, no. You're going to only work with me as an athlete exclusively for this particular period, right? We have to start flipping things over.
Yeah, the youth of it. During these playoffs, you keep hearing people refer to LeBron as old, and we should just cart him off and, tie him to an IV and let him – dude's young. He's like 38 or something, okay? It's so young how these people get these deals that impact the rest of their life. Well, I appreciate you coming and hanging out with us, Sivonnia. For people who want to learn more about the work that you do, what is the best way to connect with you?
Oh my gosh, definitely connect with me on social media at Athletes Making Moves, Facebook and Instagram, as well as TikTok. And I would love to invite you guys, if you are a student athlete, a parent, an athlete who's transitioning in any way, I would love to invite you to NIL Combine live this July. So that would be a way to help you really break down barriers to information like what we've been providing today, resources and communities so that you can properly leverage, monetize, and protect your name, image, and likeness. So definitely go to bit.ly/NIL Combine 2023 and you'll be able to sign up there.
Very cool. You're doing good work. We'll make sure to include links to that and to this document so you can take a look at it over at lawinsider.com/resources. And if you want to be a guest on the Contract Teardown Show and beat up contracts as we are wont to do, just email us. We're at community@lawinsider.com. Sivonnia, thank you again. We'll see you all in the next episode.
Thanks so much for tuning in to this episode of the Contract Teardown Show from Law Insider. If you're enjoying the show, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show. We really appreciate it. Thanks again for listening, and we'll catch you in the next episode.